Hello, friends. I hope you are doing well. For years, U.S. citizenship has been seen as the ultimate safeguard, the finish line of a long immigration journey, the moment when your place in America feels permanent and untouchable. But what if I told you that, in rare cases, that citizenship can actually be taken away? It's a thought most people don't even consider, yet history and the law make it clear the risk, while small, is very real for some. And under the political climate we've seen in recent years, especially with the Trump administration bringing immigration enforcement back to the forefront, the conversation about who can truly feel safe in their status has gained new urgency. In this video, we're going to uncover how and why the U.S. government can strip someone of their citizenship, the rare but powerful legal tools behind it, and what recent trends, especially during and after the Trump administration, tell us about the future of denaturalization in America. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Citizenship is more than just a passport or a legal status. It's a promise. It's the right to vote, to live freely in the United States, to work without visa restrictions, and to be protected by the laws of the country you call home. For people born in the U.S., that promise comes automatically under the 14th Amendment. It doesn't matter who your parents are or where they're from. If you're born on U.S. soil and subject to its jurisdiction, you're a citizen, and that status cannot be taken from you against your will. But for those who gain citizenship through naturalization, the long process of applying, proving your eligibility, meeting residency and moral character requirements, and taking the oath, the rules are different. While citizenship for most people is permanent, naturalized citizens face a legal reality that many aren't aware of. There are certain situations where the government can go back, reopen your case, and try to take that citizenship away. This process is called denaturalization, and though it's rare, it's not theoretical, it's real, it's on the books, and it has been used. Denaturalization is exactly what it sounds like, the legal revocation of a person's U.S. citizenship. It doesn't happen overnight. It's not the kind of thing that can be done quietly or casually. In fact, it's a serious process that takes place in federal court, requires a full legal case by the government, and demands clear, convincing evidence. But if successful, it strips a person of their citizenship and reverts them to whatever status they held before naturalizing, often lawful permanent resident. And for many, that can quickly lead to removal or deportation proceedings. So when can this happen? The law focuses on a few specific grounds. One is what's called illegal procurement, meaning you didn't actually meet the requirements for citizenship at the time you applied. Maybe you hadn't been a permanent resident for the required number of years, or you didn't maintain continuous residence in the U.S., or you didn't meet the good moral character standard. If the government proves that at the time you took your oath you weren't actually eligible, that can be grounds for revocation. Another ground is fraud or misrepresentation. If you lied on your naturalization application, in your interview, or during the process, and it's a lie that would have mattered to the decision, the government can try to undo your citizenship. This doesn't just mean making up false information. It can also mean leaving something out that you were legally required to disclose, such as a criminal record, prior immigration violations, or an old deportation order. The Supreme Court made it clear in 2017, in the case of Maslanjak versus United States, that the lie has to be material. In other words, it must be significant enough that it could have affected the outcome. Then there are national security grounds. If within 5 years of becoming a U.S. citizen, you're found to have been part of a group hostile to the United States, for example, a designated terrorist organization, your citizenship can be challenged. The same applies to certain military-related cases. If you gained citizenship through military service and received a dishonorable discharge before completing 5 years of honorable service, the government can take action. Now, I want to be clear, denaturalization is rare. Between 1990 and 2017, the U.S. averaged about 11 denaturalization cases a year, according to the Immigrant Legal Resource Center. But that number isn't the whole story. Under the Trump administration, the Department of Justice created a dedicated denaturalization section in 2020 with the explicit goal of finding and prosecuting more cases. Officials said the focus was on serious offenders, war criminals, human rights violators, terrorists. But civil liberties groups raised concerns that it could also be used more broadly, even for old mistakes or minor misstatements. And the data shows an uptick. About 40% of all denaturalization cases filed since 2008 happened after 2017. That doesn't mean there's a wave of people losing citizenship, but it does suggest that the government's willingness to use this tool is stronger than in decades past. Denaturalization isn't the only way to lose U.S. citizenship. There's also renunciation, which is voluntary. This is when a person intentionally gives up their citizenship. It's a big decision, and the law is clear that it has to be done with full awareness and intent. The Immigration and Nationality Act lists specific acts that can count as expatriation, like becoming a citizen of another country after age 18 with the intent to give up your U.S. status, swearing allegiance to a foreign government, serving in a foreign military that's engaged in hostilities against the U.S., or formally renouncing your citizenship at a U.S. embassy abroad. Some acts, like serving in a foreign military, don't automatically strip your citizenship unless the government can prove you did it intending to give it up. Treason or trying to overthrow the U.S. government, on the other hand, can be grounds for loss of citizenship if proven. It's worth noting that renunciation has been on the rise for other reasons, not because people dislike the U.S., but often because of tax complications or conflicts from holding dual citizenship. In 2023, around 5,900 people voluntarily gave up their U.S. citizenship, according to State Department data. So what does all of this mean for you if you're a naturalized citizen? The first takeaway is that losing your citizenship is highly unlikely, but not impossible. And because it is such a high-stakes issue, it's important to protect yourself. That starts with being truthful in all immigration applications and interviews, even if it means disclosing something uncomfortable. Keep copies of your naturalization application, your approval notice, and any relevant documents. And stay informed about your rights as a U.S. citizen, because knowing the boundaries of the law can help you avoid missteps. There's also a broader conversation here about how these powers are used. Critics of aggressive denaturalization policies warn that they could create a chilling effect, making immigrants feel that their status is never truly secure, even after citizenship. Supporters argue that the process is a necessary safeguard, ensuring that citizenship, one of the most valuable things America offers, is only granted to those who meet the legal and moral requirements. Either way, the reality is this. While the vast majority of naturalized citizens will never face a denaturalization case, the possibility exists, and political priorities can shift how often and for what reasons the government pursues them. For now, the most important thing is to be informed, be honest, and keep good records. U.S. citizenship is a profound achievement, one that opens doors, secures your place in the nation, and passes down to future generations. Protecting it is worth your attention. That's all we have for this bulletin. The U.S. Immigration Updates channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB-5 and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration Updates channel. Thank you for watching, and we'll see you in the next video.